Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on fire. Time for a girl on fire. Time for
Hello, everybody. 16 people watching, that's correct. Hold on. I need to pause that. I need to say hello to everybody. Oh, my hair is all off kilter. That's okay, we'll fix that later. I hope everybody is doing well. Yes, it goes up and down. It's correct. Guess what? I think I fixed our little... You're just gonna stop eating, Vince. Streamlabs, we got that whole thing in there. If somebody makes a really, really long message, we'll be able to see. Maybe this one. There. That's probably our little limit. Oh, there we go. Look at that. It fits all the way. That's what she said. Hey, Billy. Hope you're doing well. Hold on. Back that shit up, Paisley. Back the train up. We have some things to say. Woo! Thank you, Vicky. I can't make the sound come up, I've realized. But I'm gonna say... Well, I can actually. Hold on. But it's gonna say the wrong thing, but I mean you. That meant that was for Vicky. Happy belated birthday. And then Donald had 4 months. It says new member. It's wrong. But I do like how I've got the whole thing down there now. I love it. And yeah, thank you guys so much for being here. Thank you for putting up with all of the learning as we learn to put these messages up all the way. Hi. Every time so far. Hi, Casey Carey. Bill's here. Cellulite Yoga Pants missing for a week. Glad to see you back. Boy, do we have some doozies for you guys. Fucking doozies for you today. I was working really hard. I also had a really, really nice day with my daughter. And I really enjoyed it. We had such a blast. We went out shopping. We got her school supplies for her school. Got her some outfits that she wanted. Hi, Christopher Engelby. Okay, here we go. Look at this. It did it all. Perfect. I would love to see that spreadsheet. But look at that, D-Man. That whole chat fits. Where's Hector? Hector! I did that for you. She got her Hello Kitty charm. She is such a good kid and doesn't ask for that much. I was able to say yes to everything she wanted today, which I feel blessed about. She didn't ask for a lot, so don't get any crazy ideas. But we went to Marshall's. I think you guys have Marshall's in the States, right? I'm pretty sure. I got this outfit. First of all, this is a fucking onesie pantsuit, and it was $9. And that's the only reason I bought it. I couldn't resist. So that was my purchase for the day. And then for her, she got a bunch of different things. I was very happy with that. Marshall's is fancy TJ Maxx. Marshall's is pretty cheap here. I mean, $9. And it's a brand. Like, it's... What brand is it? I mean, it was on the clearance rack. It's Joie. Anyways. And like, this is really hard cardboard. And you know when they put that on the label, they're spending money elsewhere too. Hopefully on the clothes. Anyway, so my daughter got what she wanted. We got her school supplies that she needed. And we had a lovely day together. I was realizing I don't get the same dopamine hit that I used to get when I buy anything. In my early 20s, I mean, it didn't matter what it was, and it didn't matter what the, numbers in my bank account said. I just felt good when I bought things. Now it's not the same, but it does feel really good to buy my daughter what she wants or needs. So I guess that's called maturing? I don't know. I'm not that fucking mature. Anyways, it was good. She got, like I said, she got what she wanted. I can't do that though, Kay Crimson. I can't just be shopping on Amazon all the time. Honestly, it is very expensive to live here. I had to prioritize and set up this and plan to shop for her for back to school, which of course all parents do, but as a parent, you forego things to give them to your child. That's the way that it works. So I'm just glad that she is so absolutely, first of all, deserving of it, and she doesn't even ask. She doesn't ask that much, and what she does ask for is not like crazy. Although I did say, I'm like, baby, we're not going into Sephora. Okay, we can go to the dollar store, and we can go to Marshall's, and we were gonna go to Costco for lunch, because back in the day, Costco did not require a Costco card to go to the food court, but apparently now you do. We were pissed off about that. So anyways, and we had just a really great time. Again, she is a really great kid. Do you know what the most expensive part of the day was? Shooketh. When we were like, well, what do you want to eat since Costco won't take us? She said Subway because it was nearby, and that was like $34. I'm sorry? What? Like, that was insane to me. Absolutely insane. But of course, I tried not to, I wasn't gonna let that make me feel shitty. Hey, Fozzie! Hey! Why? Oh no. I wasn't worried, but now I'm worried. Thank you, first of all, Fozzie, for gifting 5 memberships. I think only 1 got given out, which is a very bad sign. I'll promise you, Fozzie, you're going to get your money back. I wish I got it. But, if it doesn't give them out, it tends to give them back. We may have hit the max on, oh, that happened on Colin's channel a minute ago? Or what? But, basically, I think we've come to a level of gift memberships that YouTube Daddy is saying, that's enough. You gotta get more subscribers first. But thank you. I appreciate it. I think that YouTube Daddy should appreciate your generous gift more. But evidently, it's up to me to say thank you. Vince. That's pretty much where we're at. So anyways, I hate to see that go to waste because it's a lovely gift, but I don't know. Can we put a close sign up on the memberships? Brian, thank you so much. Look at that. I love how it's, oh, it says $20. Oh my God. Thank you, Brian. You're so sweet. And Fozzie, thank you again. I really hope those memberships come through. I don't understand. If we're getting raided by Collins people, could you guys please do me a solid. Make sure that you've subscribed to the channel. Turn gifting on. People are gifting memberships and there's not enough people for them, which is actually just a sign on me to make more videos. Also, thank you again. We agree with that sentiment, YouTube Daddy. Hey, and you became a member. Amazing. Oh God, I worked actually quite hard on trying to get this to work proper today, and it didn't. Thank you guys for the raid. Please make sure that you have gifting turned on. Hi, Lizette. There we go. Ooh, it's feeling laggy. I better turn on some court before we get in trouble. Anyways, I hope everybody's doing well. We have some crazy court. I don't know if anybody's seen this yet today. I caught it early this morning. I was actually in bed. If you can believe that, I record court from bed. I wake up in the morning and I'm just like, oh, it's time. And then I just begin immediately working from my bed before I move out of my bed. Oh, look, we're going to move this. I like this. We have so many people here that I have to move over the viewer counter. Oh, not that, Paisley. God damn it. Actually, that might be locked. That's why I can't move it. Anyways, let's just switch up. This lady, I'm just going to warn you guys, adult possible content coming up. Just be aware. Be aware.
Yeah, then she can take both.
Oh my God, Vince, you're amazing. Look, I fixed this for you. Oh! Oh! Woo! And, okay, thank you, Nana Laura, for subscribing. Thank you, Vince, for the super chat. Amazing. Don't worry, that was me this morning, pulling through the chat, or through the thing to get the right timing. That's amazing, Vince. Seriously, hold on, I'm gonna hit the wrong button here. Thank you. Okay, here we go. Now I know where I'm
For the
going.
record, this matter is before the court for purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. Present is defendant mother, Shimon Johnson. Also present is attorney Hassad Hamad, representing the plaintiff Edward Kind. Mr. Kind is present with Mr. Hamad. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Parties have conferred with the front of the court. The court has received final recommendation that the child should remain in the exclusive possession of the father until such time as results are received from the mother's hair follicle tests. We thought we'd have that today.
We did think we'd have that today. I do have a question about her hair follicle tests. That hair looks bleached the fuck out to me. Respectfully, as somebody who has also bleached their hair before, is that like is she gonna what are we getting a result on? Like, what, she has fine roots, but I'm not sure that she's gonna be able to give a possible like actual test result depending on when she last colored her hair. It may be extensions. You think so, D-Man? In Michigan? They got extensions? All the ladies up in Michigan got blonde extensions? Is that what's happening? Oh, thanks so much for being here, John. I'm glad you're here. Oh, Allie! Look at you reminding me. They're going down to her toe hair. I've heard they get it from toe hair. And other areas. I don't know if that's true, Peter. I don't know. Anyways, this hearing gets heated. You're going to want to be keeping an eye out for what this lawyer up here says. Colin! Hello, my friend. We are good tonight. We are, oh, half an inner thigh hair plugs. Oh, Brian. See, you're full of actual answers. And B, you think? Landing strip? Probably. We could do a poll on that if I wasn't worried it would break the computer. I don't know why it's so laggy on the computer, but I think it's actually just a Streamlabs thing now.
Further, it's recommended that mother shall not make any posts regarding this case or Mr. Kine on her social media. And further, it's ordered that the plaintiff is requesting mother be sentenced on the contempt finding. That's the recommendation this morning. Ms. Johnson, do you understand the recommendation?
Yes, I do, Your Honor.
The status of your hair follicle test, when you were last in court, you advised the court that you had secured that drug testing on August 9th, and you would have the results by today.
I thought that was how it would work too. I did do it August 9th at 10:13 a.m. I have the paperwork. I just do not have the results. They have not dropped into my inbox, unfortunately.
Okay, you need to reach out to that facility. So the court's inclined to adopt this recommendation that the essence stay with that until such time as you have secured those results.
Your Honor, can I ask what facility Miss Johnson had taken her hair follicle test at?
Right, Ms. Johnson, what's the name of the facility?
LabCorp,
Where is that out of?
East Jordan.
What city?
East Jordan, Michigan?
Yes, East Jordan, Michigan.
Okay, so you went in actually to that East Jordan facility?
Yes, I did, Your Honor.
Okay. Well, you got to reach out to them and secure that. I guess probably we should set this for a review dates. I mean, I don't want this for Ms. Johnson to have to petition the court notice of hearing. It may be difficult for her. So we'll put a review date on this, maybe in 30 days. Mr. Ahmad, how many days was dad denied parenting time? Weeks approximately.
35 days. 35 days.
Okay. All right. So we'll set this for review in about 30 days. Ms. Johnson, if you want to get those results, you can always notice it back on for hearing before then.
Your Honor, East Jordan, Michigan that's like almost towards the UP by like Boyne City and Petoskey.
That's basically Canada, right? The UP stands for the Upper Peninsula, as far as I know. Also, I just want to say the lawyer's chair is a boss chair, right? Like an absolute boss, a king boss. Because look at his client back there, like huddled behind him, but that's just like a boss chair. I don't know distances in America. You guys drive far for certain things, and then you're like, oh God, that's so far on other things. So I don't know. In Canada, everything's a little bit far away. Everything's a little bit far away. The wall, yeah, I mean, the whole office screams, I'm gonna take your money and spend it right here. Give me your retainer. I love you, my dear. That's what I think. That's what I think is his little theme song in his head. I would love a judge chair. I have a better chair, but I move it so that it doesn't come behind me.
Can the court hear me?
Yes, yeah, I can. And again, I I didn't know where East Jordan, Michigan was located, but yeah,
It's,
that's.
it's by
Ms. Johnson's
Charlotte.
responsibility. She's got to get those hair follicle test results. So it's on her to produce those.
Well, that just seems odd to me because she was in court in Monroe. And then she was in person the following week. All right, I guess I'm just a little confused because
It's
It's
unusual.
not that far of a drive. I drove there. On the 9th, I wasn't in Monroe on the 9th. I was in Alpena on the 9th. And I do have a son that lives in Lewiston whom I frequently visit.
Okay.
East
Your Honor-
Jordan is the closest place to there. It's 80 miles. Yes, it's a far drive, but I did it.
All right, Your Honor, I would like to address one other thing with the court, if the court allows.
All right, one moment. Are you available, Mr. Hamad, on September 25 for review? September 25 and 10:30,
If I could just check my calendar, Your Honor.
please.
Your Honor, I start a mediation at 8:30.
Colin, are you making an announcement right now? Are you going to law school? I mean, you have a leg up. Don't you already have an undergraduate degree? Or a 4-year, I don't know what to call that, bachelor's? You know, during COVID, before I made my YouTube channel, I applied to law school and I did get accepted, but I would have to do like 7 years of fucking university. I was like, oh, you said yes? Oh dear. And to be clear, this was a online program at a university in British Columbia where you have to do your 4 years first, but you do it in a pre-law format, and then you would transition to the 3 years of like law school in Canada. I think that's how that works. It's 7 years as well here and in the States.
30, and then I have a Salak conference at 12. Can we do the following week?
About October, how about the week before that? I mean, obviously this child should have some contact with mother, and I hate to put this off for 6 weeks. What about do we think September 24th? How about September 24th at 2:00?
I start a trial in Wayne County Circuit Court at 11:30 that day.
Okay, how about then the 18th of,
You guys,
how about September 18th at 9:45?
that works.
All right, Mr. Pratt, could you put in as a recommendation that the court will review the matter? We'll put it back on our docket September 18th at 9:45, please.
Yes, sir.
All right, Mr. Mud, just one other issue you wanted to address?
Yes, Your Honor. So well, unless the court's adopting the recommendation, then it may address some of the social media posts that Ms. Johnson's been posting about dad being a chomo, which is a child molester.
Sir, we're on YouTube. Was anybody expecting that? Did anybody expect that? Told you I got gold today. I got gold today. He's got a lawyer to say that for him. You realize that this was possible, that they like, when you say this as, let's say he was unrepresented, it wouldn't sound very good. It wouldn't come across very well. But when the lawyer says it for some reason, I want you to listen though afterwards. What happens after they all leave is hilarious to me. Exactly, Vince. They banter about it when they leave. I was like, I can't believe, I literally was like half awake and I was like, am I recording this? I'm recording this. Excellent. Thank fucking God. This just happened this morning, so I don't know if there's anything else legal fiction, but we'll be on it. I watch this court every day.
As well as, just so the court's aware, Mr. Kind gets home and finds a writing on the door, which looks like marker on his front door saying, "You're a chomo. Mr. Kind, you deserve a knife in your chomo liver." I don't know. He doesn't know who wrote that. He doesn't, but obviously it's pertaining to this case because who else is going to do that? And I'm not suggesting we don't have proof that Ms. Johnson did it, but clearly if this is continuously hitting social media and there are her friends or family that are also getting frustrated or whatever the case may be, this might be causing those problems. And based on the contempt, it seems like Ms. Johnson just doesn't know how to stop. So I would ask the court to sentence her or partial sentence, even to pay for attorney fees. She clearly told the court she's looking for attorney. There's no attorney here. It's wasting our time as well as Mr. Kind's time. And that's what I would be asking, but I'll keep it to the court's discretion.
Certainly your position, your statements is unknown, obviously is understood, Mr. Ahmad, and obviously Mr. Kind should contact law enforcement, make a report. And maybe there's some cameras that might pick up whoever did that. And Miss Johnson, you need to rein in your friends and accomplices. I mean, they should obviously, this is clearly inappropriate. The court will order that you not post anything about Mr. Kind or Essence on social media. This is a matter before this court and you and the father. So you're gonna find yourself and spend some time in jail as a contempt sentence. I'm going to reserve a sentencing at this time, but you're pushing it, Miss Johnson, by posting things on social media. That shall immediately stop. And I suggest you bring in your friends, tell them that they're creating problems for you in your relationship with your daughter.
Your Honor,
With
if I
that
may.
said, I just forewarn you, Miss Johnson, it's got to stop, and you need to tell your friends that they are creating problems for you and your daughter, because this impacts upon you negatively.
Your Honor, and I understand she has the freedom of speech, as Ms. Johnson has stated to Ms. LaPrade, and we understand that. And her freedom of speech and under the Constitution is fine. But to talk about what this court's doing, how bad this court's moving forward in this case, how Mr. Kind is a child molester, I just don't believe it's in the best interest of the child. If in the future these two want to co-parent, this needs to stop.
The court would agree. Court fully agrees with your position, Mr. Ahmad, and hopefully Ms. Johnson is listening. So again, this matter is adjourned. Hopefully, Ms. Johnson, you come back with those hair follicle results. If you get them, pass them on to Mr. Ahmad ahead of time. And also the front of the court, right ahead of time. Don't wait till the review date of September 18th to do that. Again, you should not post anything in social media and instruct your friends not to do so about Mr. Kind. They're creating problems for you.
Thank you, Your Honor.
And so we will adjourn this matter to September 18th at 9:45. Any questions, Ms. Johnson?
No questions, Your Honor.
Okay, all right, copies will be mailed out. Ms. LaPrade will add that date to the recommendation. Now conclude this hearing. You can all zoom out. Have a good rest of the day.
You too.
Go to Shomo. Heard that, Shomo, Lily?
Never heard of it. I just looked for Facebook. Is it open to public?
Okay, but Gladys and Janice over there are really not the only people that you should ask about this. It's a known term. We know what it means. I prefer PDF file, personally. But, whatever works. PDF file just gets right through all the filters. And if you take it into any sort of other context, you figure it out. But again, just what a fucking weird Mayor. So nice to see you. So glad you're here. Let me click. I won't offer you a beer because I know you don't drink, but I do love you, Mayor. 9 months. Oh, I like that. KCC crew, 9 months. Look at how good that looks. Look at that, Does the lawyer have a calendar? Do you want to get on it? Vince, or his couch, or the chair? I know, it's a good one. It was a good one. We have more good ones coming up. Well, let's just finish what they did here. Bye, Chris. Love you. Was thinking of you today. Oh, Vince, you know what? That's a genre. Anyways, let's just keep going, baby. Can't get yourself kicked off here.
Or does she just have cover photos?
Yeah, social media creates problems nowadays, and
Oh, it absolutely does. Aaron's bringing.
I'm sorry, you
in
haven't
the-
seen this because the attorney just filed it
Okay,
yesterday on
great.
Salak.
Okay.
I just want to make sure you said that.
She's bringing them in.
Yeah, and Emma just brought up the pleadings, but she didn't know about the PPO. Had to
Yeah,
call. I had to yell down the hall. I'm sorry, you guys
She might
heard me
have,
yelling
she
for
might
her.
have seen it after.
Okay, we're good. But there is another PPO out there.
you haven't looked at them, but yeah. Yes.
On the matter of Scott Salak versus Lindy Salak.
The record of this matter is before the court in the
Oh, I'm remembering my haze this morning in bed listening to this. This one's good too. So it's the top two people that were in a relationship. I always love to ship them in my head. That's what the kids are saying these days. Not my kid. My kid's like, she just laughs at me whenever I do anything sort of hip. I can't even say hip properly. Anywho, whatever this is going on right here, I don't know. It feels a lot like the Abraham Lincoln statue. It's looking me dead in the eye. He looks like he is going to attack. It does look like it is possibly from, like, the zombie movie. What is that? What is the TV show? You know what I'm talking about. He looks like a fucking something that's about to come alive and kill you, allegedly, in my opinion. The Walking Dead, dumb. That's the one. I feel bad because as I look closer, does he have eyebrows? No. So does he shave those too? Probably not. It's probably some sort of condition, Paisley. You're a fucking bitch, Paisley. Just hit play, Paisley.
defendant mother's motion for her to show cause, alleging that plaintiff father has violated the custody agreement by communicating inappropriately with the minor children of the parties. This hearing is being conducted via Zoom. President Attorney Anthony Brusco representing the defendant mother Lindy Salak. Ms. Salak is present. In addition, Attorney John Harber is present representing the plaintiff father Scott Salak, and Mr. Salak is present. Good morning, everyone.
Good morning.
Obviously, school will be is ready. The commencement of school year is right around the corner. Obviously, the children are not going to the state of Georgia, as perhaps suggested by Dad at some point in time. There's been no motions filed in that regard. The parties have conferred with the front of the court this morning, and the recommendation this morning is that the court order that the parties not discuss any part of this case with minor children, which that's a given. And also that the plaintiff be held in contempt of court for violating the court order. Mr. Brusco, is this recommendation agreed with your client this morning?
It is, Your Honor.
Mr. Arb,
Yes, Your Honor.
does your client have any objection to the court adopting this recommendation?
No, Your Honor.
Okay, is Mr. Salak, has he moved to Georgia? Or is he still living here in Michigan?
He's relocated as of approximately June 10th, Your Honor. And he's been back to Michigan to exercise parenting time.
All right, What the court's inclined to do is takes a brief testimony from Mr. Salak this morning, find him in contempt, but to reserve sentencing. Of course, sees no purpose by imposing jail sentence, but hopefully Mr. Salak will understand this cannot continue. If it continues it, he holds the key to the jail. All right, Mr. Salak, can you raise your right hand to be sworn, please?
Unmute, Mr. Salak.
Mr. Salak, you need me, there you go. You unmute yourself. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name for the record.
Scott David Salak.
And Mr. Salak, it's been alleged that you have communicated with the children, your desire that they move with you to the state of Georgia, and that they would have a pool and the dog could come with them, things of that nature.
Oh no! Look at him. He's like, I did tell them they would have a pool and they could bring the dog if they left their miserable fucking mother in Michigan.
Do you admit, acknowledge that you discussed with your 11 and 8-year-old children the prospect of moving with you to the state of Georgia?
When I accepted the job and they asked me why, I said, yes, I would like them to. I did not say they would.
Right. Mr. Brusco, do you want to examine Mr. Salak? You're much more familiar with the specifics of the allegations.
Sure, Your Honor. Thank you.
Jean, welcome, first of all. The husband does look old enough to be her father, and she does dress older, with the exception of her whore. That was a bit of a Freudian slip. Is she a whore? Takes one to know one. Ding, 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 ding. But we all know that already about me. But seriously, no, about her little string lights there. I mean, it looks like she's got a little bit of festivity going for the occasion, unlike everybody else who could be working at a mortuary at this moment. John looks like he is either going to turn out the window or turn to the bottle, allegedly. I just feel terrible. Oh, Nico, look at that. You're inviting us over. I will give a fresh link to the Discord in a couple minutes. I don't ever whore shame. I'm a whore. I don't whore shame. I just had a Freudian slip. I just acknowledge them. But I'm definitely a whore. Oh, no, we know that. Exclamation mark. Links? We should call it kink links. No, we already have kink. Just shut up, Paisley. Hit play. Hit play!
Mr. Salak, after you learned of moving to Georgia, did you inquire of your children whether or not they would like to move with you?
I did say they were entitled to an opinion. Yes.
Okay, and did you tell them to express that opinion to their mother?
I said if they asked, yes.
I'm a little confused by that. Who asked?
But when it came up to why I was leaving, I said they're entitled to voice their opinion on the matter.
Okay, and do you now believe that they are entitled to voice their opinion on the matter?
I never said that was going to happen. I said they were entitled to an opinion, yes.
Okay, and you asked them to express that opinion to their mother?
When it came up, yes.
Okay. Judge, I believe that solidifies the allegation. He told the children about a move. He asked their opinion about a move contrary to the joint custody agreement, and then he asked the children to talk to their mother about their opinion about the move, which, of course, none of those steps along the way should have ever taken place.
Mr. Harb, do you have any questions of your client?
Yes. Mr. Salak, do you understand that moving forward, you're not to involve either child in conversations regarding change of location, change of school, change of residence, anything of that nature, or any other important decisions regarding the minor children, that you and Ms. Salak must come to agreement, and if you are unable to come to agreement, then you have to seek court approval. Do you understand those things?
Yes.
Nothing further, Your Honor.
Thank you, Mr. Harb. I think Mr. Harvey hit the nail on the head. Mr. Salak, these are matters that you discuss with your children's mother, not with the children. Yes, if you've wanted, then, or your attorney, and if your attorney files a motion to change domicile of the children, then yes, the court would talk with the children and see whether they have a preference. But it's not your role as the reality is, being divorced, it's not your role to inquire of the children what their preference is. That's for the court. So based upon the testimony you've provided this morning, the court finds the defendant Scott Salak to be, plaintiff Scott Salak to be in contempt of court for violating the conditions of the terms and conditions of the judgment of divorce and Michigan law. We'll clearly find him in contempt of court, but the court will reserve sentencing on that contempt. So it's just hopefully no, you go back to Mr. Salak. If in fact you want to, the girls to spend some time with you, holidays, summertime, you need to discuss that with their mother. And if you cannot reach agreement, then you petition the court for relief. There's a proper way to do that. Do not involve the children in these adult issues. Anything further this morning, Mr. Brusco?
Not on our part, Your Honor. Thank you.
All right, again, court reserve sentencing on contempt. Mr. Brower, could you simply add to your recommendation that court reserve sentencing on contempt?
Yes, Your Honor.
All right, anything further this morning, Mr. Arb?
Nothing further, Your Honor. Thank you.
All right, thank you. That will conclude this matter. Everyone can zoom out. Have a good rest of the morning.
Thank you, Your Honor.
You're welcome.
Ooh, thank you, Your Honor. Guess what? It's gonna get weirder and worse. Can you believe that? I don't know if you can. It's gonna. We're about to. Let's zoom over to who we affectionately call Judge Wordle. But we also know that he is absolutely always paying attention. He is not paying attention. That's right. The one, the only, Judge Brian Kirkham. That's right. And look who else is here. Let's see what it does, what it says today, Mikey baby. It still shows up special. Not over here, but you're special in my heart always. Thanks for being here. This is a weird case. And yeah, so basically, Gene, on the last case, he asked the children who were 8 years old and 11 if they would like to come live with him. They could bring their puppy and they can get a pool in Georgia. I don't know. I mean, that seems, it's tough. That's just not a conversation he's allowed to have at the moment. And that's just the way it is. But this is about to get weirder, so buckle up and enjoy. Not the first guy. This guy is, I think, as normal.
Okay, one moment, please, and I'll get the record open. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, August 21st, 2024 at 8:29 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can commence whenever you wish.
Thank you. Before the court is Chad Branch of case 213087DS. Mr. Branch is here today after failing to appear before referee Cruteau on April 4th, 2024. Bond is currently set at $2,649. This is the second bench warrant. He reports that he is employed at TNT Roofing. Last payment made on this account was in October of 2023. The Calhoun County Sheriff's Department is requesting transportation costs reimbursement in the amount of $95.66. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on August 28th, 2024 at 8:45 a.m. before this court.
Mr. Branch, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 28, 2024 at 8:45 a.m. Are you able to post a bond, sir?
I have right now, I was trying to get the money around. I have a couple of vehicles and stuff I could sell, but that's what I was trying to do right before I got arrested Saturday. Was sell my vehicles to post my bond. Now I can turn myself in, but I can't do that in here. And I was supposed to start this job Monday, 17 bucks an hour and stuff. You know what I mean? And I was gonna take care of my child support.
Oh, I almost missed it. I almost missed it. What did he say? Fucking Monday. They always start on Monday. He's giving us the hourly rate. Yeah, the hourly rate. $17 an hour, bitch. Always starting Monday. Always fucking Monday. I love it. I love it. They can never start a job last Monday. Nobody has ever started last Monday. They always start this coming Monday.
So I didn't have to keep looking over my shoulder. I missed court because I moved around quite a bit. And I think I forgot to update my address and they sent the paperwork to my old address.
Okay. Well, court notes that you do have two prior bench warrants in this matter. Court notes you have a sizable arrearage and you have not paid since October of last year. Court is taking all that into consideration. What I'm going to do is I'm going to set your bond. I'm going to reduce your bond, set it in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
Yeah, I should be able to post that in the next few days.
Okay.
I should have my brother call my car for me.
Okay, that's fine. Okay, have a good day, sir.
All right, thank you.
This next one's a doozy. Get ready. I have my excuse counter rolled back to 0. We're going to click through it together and listen to how many
Decided to
fucking
come
weird
in from
excuses.
the sunroom, huh, Mr. Chapman?
I did. It's cold out there.
Oh, go ahead.
Now before the court is Michael Hickerson of case 142454DS. Mr. Hickerson is here today after failing to appear before this court on July 10th, 2024. For the record, that was a bench warrant hearing. Mr. Hickerson was previously before the court for a bond review hearing on June 28th of 2024. He was released without bond at that time at the jail's request due to medical reasons. And then he failed to appear for the hearing. Bond is currently set at $4,815. This is the 4th bench warrant. He reports no employment. Last payment made on this account was in January of 2024. The Calhoun County Sheriff's Department is requesting transportation costs for reimbursement in the amount of $81.72. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 28th, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Hickerson, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 28, 2024 at 8:00 a.m. You will get notice of that in writing. Sir, you were in court previously on June 28th and you didn't show up on the July 10th date. Why is that?
I was told by a U.S. Marshal that because I'm a Christian that I'm being persecuted and to leave the country. He said that pretty much I need to leave as soon as possible for my safety, that me getting a job, me surviving. I have been attempted to be trafficked. A lot of attempts on my life. And I've literally been in fear for my life, running in circles. Getting a job is completely off this charts because I am in exile. I am not allowed to work a job. They will not keep me working the job. I've been trying everything in my possible. All I want is a normal life. I want to be able to work. I want to be able to keep housing. However, every homeless shelter I go to, I am impeded and imposed upon. My IDs get stolen. I get scrutinized to a point that it's unbearable. I honestly, I don't know what to do. I want to just work a normal job and pay my child support, but I am literally being ran in circles in my own country in fear for my life.
Oh, there's a lot to break down there. I got to 19. I mean, I was counting every little thing. Every little thing. Also, why he's wearing a disguise, Mikey. Oh my god. You guys, I think we need to listen again. We're going to do it together. I want you all on the ball here, listening to every excuse that he has. It starts out fucking at 100. It escalates quickly. His first sentence includes the U.S. Marshals who are telling him to leave the country. Who? What? I'm sorry, what? It was. I think it deserves at least one more listen. A better YouTuber than me would make this into a video. But I just like to watch it live with you guys. Let's go back. That was probably like 1, 2, 3, 4, 5, 6, 7, 8. There. 8 clicks.
July 10th date. Why is that?
I was told by a U.S. Marshal that because I'm a Christian that that I'm being persecuted and to leave the country. He said that pretty much I need to leave as soon as possible for my safety, that me getting a job, me surviving. I have been attempted to be trafficked. A lot of attempts on my life. And I've literally been in fear for my life, running in circles. Getting a job is completely off the charts because I am in exile. I am not allowed to work a job. They will not keep me working the job. I've been trying everything in my possible. All I want is a normal life. I want to be able to work. I want to be able to keep housing. However, every homeless shelter I go to, I am impeded and imposed upon. My IDs get stolen. I get scrutinized to a point that it's unbearable. I honestly, I don't know what to do. I want to just work a normal job and pay my child support, but I am literally being ran in circles in my own country in fear for my life. It has also come to my attention that my son is being brutally raped and is being recorded and sold on the black web. I have tried to talk to cops about it. They tell me that it is up to me as the father to take care of it. I have had no way of defending.
Oh my god, I have a terrible memory. I forgot about that part. That's right. It gets even weirder. Fuck. Paisley. Trigger warning.
Him, and it is breaking my heart. I'm doing everything in my possible just to be a good father, and I don't want to not pay child support. That is not my intent. But right now I'm in fear for my life. I am in exile and I'm living in Exodus, sir.
Okay, well, sir, sounds like the biggest bunch of nonsense I've heard in a while, but I guess that's your story. So the court will first order that you reimburse the sheriff transportation cost of $81.72. The court will note that, again, you didn't appear within almost a week of when the court had released you on no bond. What the court's going to do is set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
I will not be able to post that, so I will be sitting here until August
28th when we have your hearing. Okay,
Yes, sir.
you're free to go. Have a good day.
Yep, thank you.
Mr. Chapman, on Mr. Branch, I forgot to do the reimbursement to sheriff. Would you just have them bring that up next week and we'll do it then?
Yep, will do.
Okay, can we just take
Sorry,
one
Mr.
second and just talk about the guy that was in Middleton's court who, compared to this guy, sounds like his lawyer at this point. Also, hanky panky, that's so true. I always think it's a bit sick that they say you're free to go. But seriously, that guy, that's a 5150. But the problem is it's not a criminal charge. It's civil contempt of court for not it's civil contempt of court for not showing up to a hearing regarding him not paying his child support. So while he's entitled to a lawyer because he faces jail time, it's not exactly the same process. So I don't know that he's able to be assessed properly. I'll give him one thing. He didn't lie about starting a job on Monday. He's got that going for him.
I'd even highlighted it and then looked over it.
Then missed it. Now before the court is Timothy Spidell of cases 062081 DP and case 122453 DS. In each of these matters, Mr. Spidell is here today after failing to appear before this court on June 26, 2024. In the 2006 case, bond is currently set at $3,515. This is the 8th bench warrant. In the 2012 case, bond is currently $1,897, and this is the 6th bench warrant. He reports no employment. The last payment made on these accounts was.
Erica, hold on. Even if you face jail time in Michigan for contempt of court, although he did specifically say civil contempt of court, but hold on, I'm trying to find your comment to put it up here. I can't slow the chat down, by the way, you guys. Also, we're not there yet. Believe me, we're going to get way busier before we have to slow the chat down. You do not get free counsel for child support or family matters, only neglect, but you're facing jail. In America, when you're facing incarceration, you're entitled to an attorney. So even in cases I've seen where you're not entitled to an attorney, as soon as you're facing a jail sentence and your liberty is about to be taken away, then you get counsel, because that's the fucking basis of the system throughout all of America. And I just don't think that Michigan can get away with it. Like, he's entitled to counsel. He's being incarcerated. I think that civil contempt of court facing jail time would get him counsel. I feel like that's true, MB. I know you went to law school. I didn't. We've talked about that already. But, I mean, I hear what you guys are saying, and I know that that's absolutely true when there's children at issue, when there's child support at issue, when there's money at issue. But the second that you are in jail, I believe that or are facing jail time for a contempt charge, they just have to do it. They have to, I thought. I love to hear that. And that's why we see Sack Rider, yeah. And so what I think is that this is a failure to appear. The first guy was failure to appear. That's different. But, I don't know. I mean, also, we don't see these people being with an attorney. However, what I will say is that just like PPOs are silver, just like PPOs are silver and TPOs are gold, one is silver and one is gold. Anyways, no, protective orders, you don't get entitled to a lawyer while you're fighting the protective order. But if you're arrested on a violation of a protective order and you're facing XYZ time in prison, you absolutely are entitled to a lawyer. And again, these are just arraignments and bond first appearances where we see very often people are not always represented by lawyers. So I think I'm going with my hope that they are going to be covered with an attorney, because it does seem yucky that they're like not. But anyways, let's just keep going, see what this guy did. I'm gonna guess didn't pay child support, didn't work, blah blah blah, all the jazz.
Was in October of 2023. Front of the court recommends that reasonable bonds be set on these matters and they be scheduled for hearing on August 28th, 2024 at 8:00 a.m. before the court.
Mr. Slidell, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on 8/28/24 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir.
Okay. Well, court does note in the one case you have, it's your 8th bench warrant, the other one, your 6th bench warrant, and you haven't paid since October of 2023, and you have a sizable arrearage. What I'm going to do is reduce your bond in hopes that you could be released, but I'm gonna set your bond in each case in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day. Anything else, Mr. Chapman?
I do have some bench warrants for the record, if I may.
Okay. Go ahead.
Dominique Thorne of case 24503 UN. Philip Williams of case 16188 DP. Christopher Satchin of case 131028 DS. Onyx Warren of case 232784 DS. Nicholas Lepper of case 17.
Honestly, Billy, that shouldn't happen. I literally have it set to once every 30 minutes, which I think is fair. But I don't control YouTube, Daddy. I wish I did. I would take a lot more money. That's terrible. But, you know, I literally selected 30 minutes in between. Everybody gets ads at different time. YouTube Premium does rock. I do see that in my ad revenue. It shows up. But, yeah. I hate to hear that, because that's not what it's meant to be. Also, they don't really have an option to set it for, like, obnoxious advertising unless you do it yourself. But I specifically picked something called every 30 minutes, so.
71694 DS. Shanice Lee of cases 162102 DP and case 17729 DS. And Brett Reege of case 24351 DS. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter a bench warrant for Mr. Thorne, Mr. Williams, Mr. Satchin, Mr. Lepper, Mr. Reege, and Onyx Warren and Miss Lee as a result of their failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor.
Okay, you have a good day.
Thank you, you too.
Right.
See you, Jesus.
See you, Jeff. All right, let's move on to.
Well, no, Nico, you can set up your account to have mid-roll ads or not. Believe me, I spend a lot of time thinking and learning about YouTube monetization settings because, well, anyways, regardless. But I will, I just don't like seeing that people are getting that many ads, but it's a bit of a weird thing that's going on lately. It's hard. I get it. But I understand, Paul. I absolutely understand. So Judge just gave out all those. Was somebody's name Onyx, by the way? That's a pretty good name. Onyx? Onyx?
our other hearings. Judge, we're gonna go to Griffin
Back to
first.
Wordle. Back to Wordle. Get your score up,
Essential
Judge.
goes to your queue now. Roll Procon, everything is consent. Please unmute, ma'am. We are ready for you.
We do have the orders now.
I'm sending them to you.
Okay,
You'll see
I'm
them
just saying
in a
the notes said that we did, so that's
Okay.
why.
All right. We're calling your case now, so this is case number 2024-490.
We're calling your case now, ma'am, and we have questions. Colin's questioning pizza comas. No, Colin, because I didn't eat pizza tonight, but I want it now. Thank you. Secondly, that is not the exposed beam look that most people are looking for on Pinterest or whatever. What are people on these days? TikTok? I'm so old that I don't even know. I said Pinterest. What is this? What is going on? Where are we? I have so many questions.
PM Betsy Griffin versus Michael Griffin. It's Wednesday, August 21st, 2024 at 8:41 a.m. The defendant is not here.
Good morning, Ms. Griffin.
Good morning.
We're going to take some testimony from you, so we'll need to have you raise your right hand, be sworn in first.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. And ma'am, do you have the script that we provided you?
Yes, I do.
You can go through that now. You do not have to disclose your address.
Okay. My spouse and I were married December 6, 2020, sorry, at my house, by a person duly authorized to perform a marriage. I was a resident of the state of Michigan for at least 180 days and of Calhoun County for at least 10 days prior to filing the complete complaint for divorce. Now, before the court, the allegations in the complaint were true when I filed it and are still true today. My spouse and I ceased to live together as husband and wife. I don't know the exact date, but March 20 of 2023, it was completely done. There are one minor child born of this marriage, and I am not pregnant. There has been a breakdown of the marriage relationship to the extent that the bond of the matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant the judgment of divorce, I would not resume marital relationship with my spouse. I wish to have my maiden name of Paul restored to me. The reason that the breakdown of our marriage was because my husband.
Betsy, I'm going to hold you off there. We're going to guess. What did he do? Also, we're not allowed to make fun of her reading. We're not. I want to. It's killing me inside. Allie, I feel like she may have read it beforehand. Some people are just not good at reading or out loud. I happen to be good at reading out loud and enjoy it. But, you know, not everybody does enjoy that. And so I have to shut the fuck up when somebody's doing their goddamn best, Paisley, on a Wednesday when they have been given a script for divorce. Can you imagine if somebody came and, like, delivered it like I do? Like, I would love it. Anyways, what do we think? What do we think? What do we think? Let me get to the chat. Let me see what he did. Okay, I mean, that's a pretty good guess. Pretty good guess. Vince, you're terrible. I love it. Oh, shit. Oh, my gosh. You guys, I love your creativity. I am interested to see, at the family reunion. Oh, my God. He cheated. She is just nervous. Exactly. Is that North Dakota? Is that what that stands for? Or is it something else? But awesome. And yeah, she is. And that's what, like, here's the thing. I have to remember that. Like, I literally do public speaking every night by choice. And that's some people's nightmares. And I just, like to do it every day and twice on Sundays. So it's not everybody's thing. I hope not. I hope not. Oh my goodness. Oh my God. All right. That's it. No more bets. No more bets. No more bets. You guys are fucking hilarious though. All right. Let's see.
He was lost in drugs, and he wouldn't get help, and we tried for some time before I decided that it was just best for me and my children to completely stop this the marriage and separate. At this point we co-parent pretty well. Our communication's better. He's gotten caught with the drug that he was having a problem with, and he is now, clean due to he's on mental health court. So
Okay, and this is just terribly sad, Paisley, yet again, why you don't fucking make fun of people, but I do. Good night, Colin. This chat is definitely not PG-13. I always laugh whenever I'm over at yours, and I just think to myself, I'm not PG-13. I'm just not. I haven't ever been. I wasn't PG-13 when I was under 13. Anyways, but this is sad, but the exposed beam trailer is making a little bit more sense at this point. I mean, I guess it's not that sad. It could be worse. She could just stay, right? She could just stay.
Oh, good. Ma'am, I'm looking at the proposed judgment. Has what purports to be your husband's signature. Do you recognize that as his signature?
yes.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. I have signed the judgment of divorce. Ma'am, you are now divorced. Best of luck to you. I hope everything works out for you. And you're free to go and have a wonderful day.
Thank you.
Let's move on.
Back to the Scrabble. No, it's Wordle. He's playing Wordle.
Please unmute, sir. Mr. Love.
Sir, please.
Okay.
Oh
Can you
my
both
God.
hear us?
Oh.
I can.
Oh. Oh. He's got so much grease on his screen. Sir, wipe it off. That's what she said. But seriously, wipe it off. Ugh. This becomes my biggest pet peeve in the world.
Hear you.
Ma'am, can you
I
hear
can
us?
hear you too.
Okay.
Yeah.
Thank you for your patience, both of you. This is case number 2024-38 DM. It's Wednesday, August 21st, 2024 at 8:45 a.m.
Okay. Good morning to both of you.
Good morning.
Good morning.
Court notes that this matter is before the court today for the pro confessor hearing. However, the court does note as well that the plaintiff has filed a motion for revocation of paternity, which is set for the 26th in this matter. Sir, are you aware of that she's filed that motion?
I'm aware.
Okay. And as a result, what I can do is I can take and preserve the proofs in this matter, but I cannot grant a divorce until such time as we have, first of all, she hasn't given birth. So I can't do it until such time as that. And then plus, we have to take care of the other issue as it relates to the paternity.
Okay, so we can learning opportunity. I'm sorry for coughing. So she is currently pregnant, which means that you cannot get divorced while you're currently pregnant. They will take the proofs like we're doing in this case today, but because she's pregnant, a child born of a marriage in Michigan is the legal what is the weird word that they say? The legal seed? No, it's not seed. That's a porn word, Paisley. It's another one. The legal offspring. It's the legal product or something like that of the child, of the issue. It's the legal issue. That's what it is, Vince. Thank you. They are the legal issue of the father. And so until she gives birth and then submits a revocation of paternity, they will not be able to get divorced in the state of Michigan. That's why they ask the question. Now, we have a pregnant cheater allegedly at this point, but I'll draw your attention to earlier this year when I covered a case where we had somebody brought back to court to answer for the lies she told on the stand about being pregnant. It was exactly this problem, basically, except nobody's going to be mad at you if you're pregnant. You just got to say it, and you have to go through a longer process. But you can't lie about it, and that's what happened last time. She gave birth, and then her ex-husband came back to court and was like, there's a baby. And she had to admit that, and she was found in contempt. That was quite the day as well. Quite the day. Now, she thought that she was getting around the issue by lying, but that doesn't do it, ma'am. Anyways, at least this one they seem to know. Also, is his last name Love? That's sad.
What I will do, because typically we don't do on the motions for revocation of paternity, we don't handle, we handle the motions on Monday, because that's our motion day, but we don't take testimony on that day. In this case, I'll need to take some testimony in this regard concerning the motion. So I'd have to have you back on another Wednesday. What I'll do is I will set the matter over for a Wednesday, and that way you wouldn't have to come in on the 26th. So it'll save you having another court proceeding, because I did have an opportunity to review the motion. The court does find.
In the case that I'm talking about earlier this year, she absolutely did know. She gave birth within a month of the hearing. So she was 8 months pregnant when she answered the question, are you currently or could you be pregnant? It was indisputable.
That there's sufficient basis in the motion to send the matter for a hearing and take testimony. So at this point, I guess I'll just save you having to appear on the 26th.
Okay. No way we can deal with that today, because me and the defendant have been separated for 2 years.
No, I'm gonna have to, because I don't have that part of the file with me or anything. We'll have to set it for a Wednesday. It'll be set for a Wednesday afternoon at 1:30, and then we will take testimony at that time from both parties.
Okay.
Ms. Love, we'll have you sworn in, because we do have to take some testimony from you on the breakdown of the marriage, and then I'll let you go through. And do you have the script that we provided you, ma'am?
Yes, I do.
Okay. We'll have you raise your right hand. We'll have you sworn in, then we'll proceed.
Do you solemnly
You want me
swear
to
or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. You can go ahead through the script, ma'am. You don't have to disclose your address if you don't wish.
Okay. My full name is Haley Alexis Love. My address is 44 Babcock Ave, Battle Creek, Michigan. I am the plaintiff in this case. I married the defendant on 12/7/2018 in Kalamazoo, Michigan. I filed a complaint for divorce on January 5th, 2024. I've lived in Michigan for 180 days in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all statements were true. All statements in my complaint for divorce are still true today. There's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I do not believe that there is any possibility of reconciliation. I am currently pregnant, I'm sorry. The defendant and I have 2 minor children together. Their names and ages are Killian Austin Scott Love, 3, and Eliza Rose Love, 2. I have read all the terms.
Did she just say Chili? She named her kid Chili? Is that what she said? Oh my god. She is a better reader. I feel bad about that. Let's just do a little PSA. Do you know that there is a large percentage of the United States that is illiterate? Adult population, non-immigrant, actual illiteracy. I learned that from What Would You Do? Okay? Where I learned all my empathy skills and what to do in serious situations. Anyways, they said that they've been apart for 2 years and she's only just pregnant. So I don't think she's a cheater, but, you know.
Of the proposed judgment of divorce, and I agree with them. I would like the court to change my surname to Matheny. I ask this court to grant an absolute judgment of divorce. Thank you, Your Honor.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending resolution of the other matters before the court. And so you're not divorced until I actually sign that final judgment. I'll ask you, Mr. Love, is there anything that you're disputing or contesting as it relates to the judgment?
Not entirely. I do have one thing I would like to address concerning just custody over Killian and Eliza. I think that she wrote down that she wanted full physical and sole custody of them. And I'm not in agreement with that. I didn't see that part, and I didn't quite understand what it meant when she filled out the paperwork. Okay. I don't want her to have the ability to take my children and me not have a say if they go out of state. I want to be able to be involved in their school lives, and I want to be an involved father, and I feel like that takes that away from me. It kind of gives her the high ground to take away what she wants to take away and give what she wants to give. So I would like to have split custody.
Yeah. Okay. Well, sir, hold on. Sir, if you want to be involved, you have to take action to be involved. You just can't show up on one occasion. In this particular matter, you've been defaulted. And if you want to contest matters, you're going to have to file a motion to set aside the default. And then if the court sets aside the default, then you're going to have to take action to seek custody. Okay.
So in case you missed that, he didn't show up to the earlier friend of the court meetings or hearings, and so he didn't file a response to the lawsuit, and he is shit out of luck at this point. He's lost this lawsuit. He would need to hire an attorney yesterday to get this dealt with, to file an appeal within this really quick amount of time to have this overturned and a new hearing. But that costs money, and it doesn't cost money to show up at your hearings. I mean, it would be smart to bring a lawyer, but at the beginning, you need to show up. That's the key factor here. Because when he says this at the beginning, they have to listen, you know? Interesting, but again, a little too late at this point. And the judge knows it. I mean, bro, I don't know if you heard earlier or not, that guy talking about the U.S. Marshals and his son being raped and all these different things, and he basically like laughed in his face and said peace. So you're gonna have to do better than that, Mr. Love.
Okay,
Okay.
but
I'd like to also make it known that this entire time, me and her have been split. I have seen my kids every other weekend. At one point, it was every weekend.
Okay. Well, let me tell you, none of that makes a difference as it relates to the fact that a default's been entered. You have
Okay.
to file a motion to set aside the default. You have to schedule that motion up, come before the court. The court I will consider what the reasons are for your being defaulted. And then we can proceed from there. But if you want to have a say-so, as you're claiming, you need to take action. You just can't sit back and do nothing. Okay? You will have some time because the court's not going to enter the judgment in view of the issues concerning revocation of paternity. So you have some time, but don't wait that time. I would say if you haven't done something in a couple of weeks, you risk, again, not getting anything out of this case, okay?
Yeah, any help I've tried to seek, I just haven't had any success.
Well, that doesn't matter. You still have to, if again, you can't come to an agreement, you have to bring the matter before the court, which you have not done.
Okay.
So if you take action in this matter, then the court can do something, but until then, I can't because a default's been entered. So I'll just let you know that the court, as I say, the court will find that the testimony did establish the statutory basis. There was a showing there's been a breakdown of the marital relationship, and we'll simply preserve that proof pending all of the other action in this case. You're free to go today and have a good day. We will let you know the Wednesday when we're able to take the testimony concerning the revocation.
And Judge, we'll do that after the
Thank you.
Okay.
Thank you.
Right.
Okay, thank you. Have a good day.
You as well.
You too.
All right, we'll close the record here.
Hi, Hector. I fixed it just for you. Well, not just for you, for all of us. But I fixed it. It should put all these long comments up here. Look at that. By the way, guys, Hector's channel's back up and running. Yes. Excellent. YouTube Daddy tried to push him down, and we said, no, no, no. That's not the way it goes. Don't worry. I have more court for us. Don't you fucking worry. We are moving on to the next thing, which I believe was this one.
He's got to get his audio out here.
What does Deborah's thing say? The will of...
Good morning.
Good morning.
The wall of...
Morning.
something.
Oh, here he
Morning.
comes in. Okay, we got everybody. No, he knows. Oh, yeah. I think after 10 years, I'd figure that out. No, you can't touch it. No.
What are they talking about? What are you guys talking about? Can you talk louder or quieter, one or the other, please? Also, you guys, did I mention that this is a full-on, like, onesie pantsuit? Like, if I had an office job, I would be wearing this. I think it would be a Monday outfit.
Okay.
With some boss heels.
Really the matter is that Jeffrey Hill.
For the record, this matter is before the court for the purpose of entering a proposed consent judgment of divorce. This hearing is being conducted via Zoom. Present is Attorney Carmen Moyer representing the plaintiff. Good morning, Ms. Moyer.
Good morning. How are you, Judge?
Wonderful, thank you. And also Ms. Deborah White is present. Is Jeffrey Hill present in audio?
Yes, sir. I'm here, Your Honor.
All right, good morning, Mr. Hill.
Good morning, sir.
White, Mr. Hill, good morning. Can you both please raise your right hand to be sworn, please, Mr. Hill and Ms. White? Do you both solemnly swear?
Yes,
affirm that
sir.
The testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Mr. Hill?
I do.
Thank you. Ms. Moyer, you can be with Ms. White, please.
Yes.
Yes, sir.
Okay, Mr. Hill, Ms. White, Ms. Moyer's going to ask Ms. White a few questions, and then after she's done, I'm going to ask you a few questions, okay?
Yes, sir.
Okay, Ms. Moyer.
Good morning, Ms. White. How are you?
Great. How are you?
I'm doing well. Can you just state your full name for the record, please?
Deborah Ann White.
And at the time you filed your complaint for divorce on or about May 17th, 2024, had you been a resident of the state of Michigan for at least 6 months?
Yes.
And a resident of Monroe County for at least 10 days?
Yes.
And when we filed your complaint, were the allegations in it true at the time?
Yes.
And are they still true today?
Yes.
And one of those allegations was that there'd been a breakdown of the marriage relationship such that the objects of matrimony could not be preserved, and there's no reasonable likelihood of reconciliation. Is that true?
True.
Are you pregnant?
No.
And you saw the consent judgment of divorce that we prepared and is in front of the judge today, and you signed it. Is that correct?
Yes.
And do you believe that to be a full and fair distribution of any property or debt between you and your husband?
Yes.
And would you like the judge to enter that executed judgment of divorce today and waive your right to trial?
Yes.
No further questions, Your Honor.
Thank you, Ms. Moyer. Mr. Hill, can you please state your name and current mailing address for the record?
Oh, I'm sorry, Your Honor, you're a little muffled. Can you repeat that question again?
Can you please state your name and current mailing address?
Yes, sir. My full name is Jeffrey Richmond Hill, and my full mailing address is 49203.
Thank you. Mr. Hill, did you hear the testimony this morning of your wife, Deborah?
Yes, I did, sir.
Was her testimony true and accurate to the best of your knowledge?
Yes, as far as I know of, yes, sir.
And is it true that you signed your name to this judgment of divorce approving the terms and conditions contained therein?
Yes, sir. I signed all the necessary documents.
Did you do so freely and voluntarily?
Oh, yes, sir. Yes.
And you've agreed to pay to to reimburse to Deborah $850 as contribution toward the attorney fees that she's incurred. Is that correct?
Yes, I have already done that, sir.
Okay, all right, good. And you understand, even though Ms. Moyer is helping resolve this matter, she's prepared this document known as a judgment of divorce. She represents Deborah. Her loyalties lie with Deborah. Do you understand that, sir?
Yes, sir.
Do you have any questions for the court?
Not that I can think of, Your Honor. No.
Thank you. Ms. Moyer, do you have any questions of Mr. Hill?
I do not.
Very well, the court would like to thank and acknowledge Ms. Moyer for her assistance in helping facilitate ample resolution of this matter based upon the testimony that's been presented this morning, as well as complaint filed in this case. The court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce from bonds of matrimony. The court has assigned the judgment on base electronically this morning. A copy will be mailed out. Good luck to you, Ms. White and Mr. Hill. That will conclude this hearing. And with the entry of this judgment today, the court will vacate and cancel the pretrial conference scheduled for tomorrow, which is August 22nd.
Thank you, Your Honor.
Thank you.
All right, so good luck to both of you. That will conclude the hearing. You can all zoom out. Have a good rest of the day.
Have a great day.
You too.
Thank you.
Okay. Yes, you, thank you.
You're welcome. Good luck, sir.
Yes, yes, sir, Your Honor. Thank you very much.
You're welcome, Mr. L.
Do you think he was always late in their marriage and that's why they divorced?
You gotta come out and put that in the record. Time? You have a time?
You spoke too soon, Vince. Look at Shelly.
Yep. For the record, this matter is before the court for the purpose of reviewing all outstanding issues, which are post-judgment issues. This hearing is being conducted via Zoom. President Attorney James Bartlett, representing the plaintiff Troy Licata, and Mr. Licata appears to be present with Mr. Bartlett. In addition, Attorney Maria Zagorski is present, representing the defendant, Michelle Licata, and Mr. Licata appears to be present. Good morning, everyone.
Good morning.
Good morning.
Parties have conferred with Ms. Brower from the front of the court this morning. It was advised that Attorney Zagorski will submit an order regarding the quadro under the 7-day rule. That was one of the questions the court had. I believe that was one of the outstanding issues was to us of the QDRO. And that's been approved by, or it's not been approved by the plaintiff. Is that correct, Ms. Zagorski? You're submitting that under the 7-day rule?
It's pre-approved, if I may, pre-approved. I had Mr. Licata had brought up a question for me that I'm going to either order the transcript or if you allow me to listen to the tape regarding valuation date. But I can get that taken care of within 24 hours. And, you know, the language is okay. Just there was a question Mr. Licata had regarding valuation date. Due to the fact it was put 2 years on the record 2 years ago, I don't have a photographic memory, and my notes reflect that Ms. Zagorski's do not. So I just want to double check. Thank you.
All right, very well. Are you going to hold off submitting that under the 7-day rule to Mr. Bartlett reviews the transcript with you, Ms. Zagorski?
I've calendared it up for Friday, Your Honor. Right.
Okay. It's further recommended that the court review put back on its docket September 4th at 1:30 to review other outstanding issues. The only outstanding issue is the spousal support arrearages, correct?
And Ms. Zagorski's attorney fees, correct?
Yes, Judge, the last time we were here, you suggested that Mr. Licata get a home equity line of credit or take some action to make a significant payment toward those arrears. He has not.
Yes, the court noted he was to present a plan. So he's still working on his plan, Mr. Bartlett?
Well, correct. And we had confirmed with his bankruptcy attorney's office, did not speak on them directly, that there might be some hoops that need to be jumped through there. Ms. Zagorski, my understanding, will be speaking with the bankruptcy trustee for further information. And I mean, we'll proceed from there. So no, I don't have a step A, step B, step C kind of plan. Still a little nebulous, but we're working on it.
So is Mr. Licata paying any spousal support right now?
It is coming out by income withholding order. He went back to work approximately 3 weeks ago. So it's coming out of his current employer, First Solar, and there was a partial pay out of his last employer, the Andersons. So there is money coming out by income withholding order.
All right, is this recommendation agreeable then, Mr. Zagorski, putting this over to September 4th at 1:30?
But it is, Judge. I just need to get some more information from the trustee.
Okay. Likewise, Ms. Bartlett, is the recommendation agreeable with you and your client?
It is, and I know Ms. Zagorski needs to get more information, and I need to take a listen to the judgment that was placed on the record. Thank you.
Well, this is like 2 weeks away. Will this give you enough time? I'm loath to keep bumping these things on and on and on and on. It's a post-judgment matter. I mean, do we need to give you 30 days? I want Mr. Licata to come back with a concrete proposal. What assets he's going to sell, what he can Does he need to, when's he gonna be out of bankruptcy, Mr. Bartlett?
To give you a little bit of history there, my understanding is that at one point, I believe Ms. Zagorski had pulled it up on August 6th. If I'm off on that date, I apologize. That there was a petition to terminate or dismiss his bankruptcy. Mr. Matt Vivian, who used to work in Monroe, you probably recall him, is the attorney handling his bankruptcy. I did not speak with Mr. Vivian directly this morning, but his office confirmed that they had responded to that. That there will be a hearing on that matter, although I don't believe she had the date at her fingertips. And I have spoken off and on with Mr. Vivian regarding Mr. Licata's bankruptcy proceedings. I don't know, probably every month and a half or so to see where it stands. So that's what's up.
So I guess the bottom line
Right.
question is that going to be sufficient time, September 4th, or do you need to bump it out further into late September? The court wants Mr. Licata to come back with a plan. So if he needs more time to have that concrete plan, we need to address these are, as the court calls, pretty significant spousal board arrearages.
So yeah, it's almost $15,000, Judge. And there was an order entered in November that's refinanced his mortgage loan with Directions Credit Union. His mortgage loan at that time was, the balance was $20,000. You had suggested that he get a home equity line of credit, and he claims today that he cannot. It's a Chapter 13, so he's under an organized plan. And so that was my question to the trustee, is whether he can take some equity out of that house to pay my client. He says he can't. I don't know whether that's true or not.
And if I
Was it
may,
September?
and if that was where I was going, Your Honor, if I'm agreeable to the court's suggestion of continuing it out further so that everybody has some more time and a more thorough plan. At the same time, I had agreed to the quick review because I know Ms. Zagorski's client needs the money and is concerned. So I would just defer to the court as to how you wish to schedule it.
So you want to keep it on September 4th, Mr. Zagorski?
Yeah, I understand your point, Your Honor. My concern is that we're 2 years out from the judgment. We're just entering the quadros. You told him last month to come back with a plan and he didn't. So I'm afraid that if we don't hold his feet to the fire, nothing will happen. That's all.
All right, then we'll put this back in our docket September 4th at 1:30. Anything further than this morning?
No, thank you, Judge.
All right, that will conclude, sir. You can all zoom out. Have a good rest of the day.
Okay.
Thank you.
Yeah, Maria's a warrior. Shelly looks like she's been waiting 15 years or 5 years or whatever. Let's just watch. I was ejecting one of my multiple USB drives that I use. Now that I'm lucky enough to have 2 computers, I can be working on one and also recording on one and the other. So I need these to move them about. And I have learned that you're supposed to eject them properly. And so I do. A map one is a network drive on the other. Probably a good idea, but I don't know. I don't need it to be easy, K Crimson. The problem is I could dump a fuck ton onto the new one. I don't need to do that. I need to be better. KD9's late. That's okay. The case that I'm uploading here right now is directly related to that one in a sense that it deals with a quadro, and I think it's a fucking really good lesson to be learned. So we will watch that one. Let's watch one more Bronlick, and then we'll get to that one. And then that will be it for the night, I think. That's alright. That's amore. I put them right here in a little folder. That's amore. How long was that? We say, oh, it was 13:53. Now it's this one.
I worked with Frank and Pete when he was in private practice. I remember when you were just a little thing.
Oh yeah, I remember coming to their office all the time. They would give
Yeah.
me candy and I would get to hang out with all the cool people there. It was
I was one of
an
those
awesome
people.
experience. What's that?
Judge should be out in a minute.
Okay.
Just hang tight there.
Wow. I haven't seen this one yet. That surprised me. Oh, take it off. Colin. Yeah, you look okay. But Vince would like to see under your shirt.
Selena might make an appearance. Might make an appearance.
Hold on, I want to hear what she just said. Who fucked who? These are the questions. I'm thinking it's these two. But let's see here. The guy's name is spelt Colin. That's how I would say it.
Mark Ethel's all over. Once you become 62, you get them all.
Selena might make an appearance.
Got them all over the place. Yeah. Oh, wait, no, don't think. Oh. It's an age spot.
No, it's a bruise.
You sure? Yeah. I bumped it. That doesn't look like a bruise. That looks like cancer. It's got a weird look to it.
What are they talking about? Also, what I really want, and anybody that uses a lot of data, honestly, you should use a system or a program called Backblaze, which is like automatic upload from your computer onto remote servers, and they'll send you hard drives whenever you want upon request, and there's no limit to the amount that you can upload. So I heard about it from another YouTuber that has like 17 channels, and he's like, they actually do not like me to talk about this fact that it is you know, not limited. But I mean, my data is wherever it is. I think that will be a one day. It costs money, right? Like you have to pay the bill every month and upload it every week or day or however often they do it. But it is really good quality, and I've heard from a number of YouTubers that it's sort of like the best way, especially for large video data storage. It's probably one of the best that isn't subject to, like, you can't upload all that to YouTube. I've learned that the hard way.
Take it off.
I can't take one. Cold. Right on a vein. The frizz is off, so I can't.
Makes it worse.
Yeah, I don't know.
Second age spot is cancer, I think.
It's not terrible. Okay. I just gotta put that money in the bank.
The reason I say that Backblaze is good, because here's the deal. If you make court content or make content where you have a large amount of content that you have to sift through to find good clips, then being able to store that without worry of like, oh, I've filled up another, like I can fill up a terabyte very quickly. You have to be careful. So ideally, if you don't want to have to be careful about it, it's the ideal. Judge, where are you? Hector, you should look into it as well. Again, I'm just... It's probably an absolute write-off as well for a person who runs a YouTube channel. What the fuck was that? Who's moaning? Is this a sex tape?
You're not until the mornings. I guess you can knock again. You know? Yeah, right. Yeah. Good idea.
We're ready, Judge.
That guy? No. Is that who you mean, Hector? No. I have a type and that is not it.
Just, I could hear him go get into his closet though. He's getting his room.
I'll say it again, but also just Google it, Backblaze, and I'm sure there's YouTubers that have promo codes for it, so just Google that first as well, because I've seen that before. But it's Backblaze. So. Is that the door, Judge? Please. Please.
Did he get my badge yesterday?
Oh, he's putting on a cross. Ladies and gentlemen, he's putting on a cross. And she's whispering, did he get my vag yesterday?
He doesn't pay for anything. He isn't working.
Albin?
Yeah, remember the.
Yeah, I think it's Monday.
Is it Monday?
I think it's Monday, yeah.
We had her full.
Mhm.
Just that was a few.
Yeah, I know it's next week though.
Hurry it up, Judge. I'm trying to get this thing for Jonathan because he makes a good point. I can type that, but I can't get the Discord link. But I'm on 2 different computers, Jonathan. But I will. I will. Also, come on. I guess I can go forward. Oh my god, look at all this. We're skipping. There we go. Fucking finally. Jesus Christ.
Court has received the following recommendation. That the referee recommend order be adopted and modified as follows: that the minor child's name is Elena Renee Quinn Stango. That is a recommendation. Ms. Quinn, is this recommendation agreeable with your client this morning?
Yes, Your Honor.
Okay. Ms. Stango, do you understand the recommendation?
Yes, Your Honor.
This recommendation? Ms. Stango, do you have any objection to the court adopting this recommendation?
No, Your Honor.
Right. Is your daughter's on the birth certificate? Is that her name on the birth certificate?
At the moment, it is just Stango. Excuse me. But we would like to change it to Quinn Stango.
Right. So you're agreeable to changing it to Quinn with Dad's name and then your name, Quinn Stango. Is that correct?
Correct, Your Honor.
So you will cooperate with respect to completing any paperwork that needs to be sent to the state?
Yes, Your Honor.
Ms. Quinn, obviously you'll get the documents and you'll submit that to Ms. Stango for her approval then?
Yes, Your Honor, I will. What I will say is after meeting with Ms. LaPrade, with friend of the court, Ms. Stango made us aware that the child was born in Ohio, in Toledo, Ohio. So we weren't sure whether that, whether the terms regarding the birth record fee needed to be changed to reflect the jurisdiction the child was born in, or whether it should stay Michigan Department of Health and Human Services, whether the birth record fee should be submitted there.
I think you just need to track down the Ohio forms. If the child is born in Ohio, then you need to submit those the forms to change your last name with the Ohio authorities. So you want to get the Ohio forms to provide for that. But obviously with this recommendation, which court will adopt, Ms. Dangle will cooperate with respect to signing those forms to modify the child's last name. Right, anything further than this morning, Ms. Quinn or Ms. Dangle?
The only thing you're on, I'm sorry, on page 3, the birth record fee, would my client still pay the $59 to the Michigan Department of Health and Human Services to have the birth record amended? Because it would be my understanding that there is no birth record with the Michigan Department of Health and Human Services if the child was born in Ohio.
Correct. So whatever fee there might be to the state of Ohio, that's the only fee that has to be paid.
Yes,
So
and
yeah,
I will
I
make
think
that my client pays that.
Yeah, you can ignore that provision in the judgment affiliation because obviously it doesn't apply.
And with that,
Right.
I have nothing further, Your Honor. We would waive any objection to the judgment affiliation.
All right, thank you, Ms. Quinn and Ms. Dangle. Anything further?
No, Your Honor.
All right, that concludes hearing. A copy of the order will be sent to both parties. Well, good luck to
Look, I inserted it. Oh, yeah, it'll work. Anyways, hold on. This is our last case for the evening, and it's a doozy. It is also about quadros, which, if you're a lawyer, there's a few out there. You know what a quadro is, and you know how fucking annoying they are. And persnickety, let's say. Persnickety? But I don't know if you know it like this. Give me 1 second to move this over. It'll just, well, you'll see. Look at that. You're watching. We're gonna watch together. This is usually behind the scenes, but it's going very fast, so it's okay. We'll be fine. And then I will eject the thing, and then I will start the video. Just talk you through the whole thing there. I hope you enjoy that. Eject. Eject. That's what she said. Eject. Oh, I guess, well, I did. Anyways. Then we go like this. It is like a diss. Seriously though, this is like legit situation. Don't fucking do what this is. This guy is doing. Oh my god, I'm so glad that's not on there. That was my boobs. Jesus, scared myself quite a bit there. Untitled video.
Okay.
I don't want to get shut down for boobs.
Okay, we are live on the record in cause number 83 FD 1854. This is a motion to enter for entry of a qualified domestic relations order for child support. This pleading was filed by the Attorney General's office July 15th of 2024. All parties are present on Zoom today. This is a remote proceeding, and I am sitting outside of Galveston County pursuant to the Texas Family Code, section 201.1045. And I find that nobody has filed any objection to proceeding in this manner. Mr. Hockley, can you please state your full name for the record, please?
Vaughn Jane Hockley Sr.
Thank you. And Ms. Hockley, can you please state your full name for the record, please? Charlotte Yvette Hockley. Okay, thank you. And can you both please raise your right hands? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You may lower your hands. And counsel for the Attorney General's office, please state your name.
Elvira Villarreal for the Office of the Attorney General.
And you can proceed.
Thank you, Judge. Judge, yes, the Office of the Attorney General did file this motion for entry of the qualified domestic relation order in this case. I would like to ask the court to take judicial notice of the attached states exhibits to said motion for entry, which includes States Exhibit A, which was the agreed support decree, that was signed back on February 13th, 1984, which ordered Mr. Hockley to.
Did you catch that? Did you catch that? Their divorce decree is older than me. I was born in 1988. This divorce decree, 1984? It gets worse. The numbers, the math ain't mathing, ladies and gentlemen. The math ain't mathing. We are in 2024, in case anybody's watching this in the future and you don't want to look and look. The date today is August 21st, 2024.
Pay support on this case for in the amount of $100 per month beginning February 5th, 1984. Payable on the 5th and 20th day of each month thereafter, along with State's Exhibit B, which is the order confirming child support arrearage that was signed back on January 10th of 2005. And in that order, it did confirm the child support judgment as of November 30th, 2004 in the amount of $19,581.60, and set a payout for said child support judgment of $100 per month beginning February 1st, 2005. Exhibit C is the payment record associated to the child support case in this suit.
I do see those pleadings as well as the exhibits that you referenced. Thank you for explaining them. So I do take judicial notice of that entire pleading with attachments. That was filed July 15th, 2024.
And Judge, at this time, there is it seems to be only one dispute as far as Mr. Hockley is concerned with entering the quadro. There doesn't seem to be a dispute regarding the arrearage that is owed on this case, Judge. It seems that Mr. Hockley's dispute to the entry of the quadro is that there might not be any there may not be sufficient funds to cover the amount. Judge, it is the state's position that the quadro that was prepared by the administrator does include that the child support arrears, when it was prepared, was in the amount of $27,384.63. It's the state's position that if there are insufficient funds on the day of the valuation date or the day of the collection, we would not take anything more but what is in the account. And I do want to make it clear.
So MB, the question I have for you is, are they asking for a lump sum payment out of his plan, his retirement pension, basically? Is that what a qualified domestic relations order is? Or would it set up $100 monthly payment going out, is my question. That's my thought. They're asking for the full lump, a lumpy sum. Oh, baby. Would we like that? And you don't get taxed on child support, do you? I don't think you do. I don't think you should be taxed on child support because somebody already paid fucking taxes on that the first time. Anyways.
That if there are more funds than what is actually owed, we would only take out the amount that is currently owed. And as far as the state's position, we are asking that the quadro be entered, as we do believe it's appropriate. There is a Compass Group retirement plan in this case that has funds, whether the funds at the time of the preparation the quadro may differ from today or at the time that we actually receive the funds or collect money. That is possible. But we would like to enter the quadro to collect from that retirement account, Judge. And that's the state's position. And if you want, Your Honor, I can call the parties as a witness or whichever way you would like to.
I guess I'll start by letting Mr. Hockley speak, and then if it seems like he needs more direction, I'll let you ask him some questions.
Yes, Judge.
Mr. Hockley, it sounds like
Yes,
you're not
ma'am.
agreeing to the quadro, so I want to give you a chance to explain your position.
What you mean by that?
Well, the state is asking that I enter the quadro to pay off the arrears, like Ms. Villarreal just explained. My understanding is the reason you're before me and having a hearing is that you don't agree to what the state's requesting. Is that true?
I don't understand.
Okay. Do you understand that the state's claiming you have arrears for child support?
I believe that's right.
Okay.
But
And then
the
the
problem is,
I'm sorry?
I'm stating is that at the time I signed the agreement, they were supposed to be taken out of they were supposed to be garnishing my wages back starting in 2005. But for some reason, they didn't.
Okay.
So I guess they say they just started taking it out in 2014. So that's my only dispute is when I signed the papers allowing them to garnish my wages in 2005, they didn't start garnishing my wages till 2014.
Okay. So you agree that she didn't receive payments from you more or less from 2005 to 2014. It looks like there was one payment in March of 2005, but generally in that time period, payments were not being received by Ms. Hockley for child support.
I didn't know that. I thought they would I thought they were garnishing my wages because I had signed papers giving them authority to garnish my wages. So I didn't know they wasn't taken out because I wasn't following them or nothing like that. So I thought they were garnishing my wages as of 2005. But when I got the papers, they say they started garnishing in 2014. So I didn't know they wasn't garnishing. So I wasn't feel I wasn't obligated to send nothing when I thought they were taking it.
Okay. Ms. Hockley, is there anything you'd like to say? Are you there?
Yes, ma'am. I'm not understanding why he signed the paper saying they supposed to garnish it. Why he saying he don't understand? He signed the papers. They said they didn't take it out, but I ain't get it.
Sir, are you claiming that it got taken out but not sent to Ms. Hockley, or you're just saying you didn't look and didn't know that they weren't taking it out?
Yeah, I didn't pay no attention to it because they said they were taking it out, so I figured they were taking it out. So I just figured they were taking it out.
And I don't know what happened back in 2005, sir. I can tell you now that I routinely lecture people, and I hate to use the word lecture, but it's almost a lecture, that even though the Attorney General's office should be withholding, sometimes people have jobs where they can't withhold, or sometimes glitches happen sometimes the glitch is on the end of the company, sometimes the glitch is on the end of the AG, but glitches do happen. And ultimately, I let the person know they're responsible for making child support payments. I routinely tell people, look at your check. If it's not coming out, get with your company and make the payment yourself. So ultimately, even though you felt it should have been coming out, everything I'm seeing shows it didn't come out, so the arrears are still owed. So even though it's unfortunate, and I'm sorry that you thought it was being taken care of all these years, but you had the benefit of those monies all those years.
Yeah, I thought they were taking it out. Why?
Absolutely willful ignorance. Good night, Courtney. We're on the way behind you. Just 3 minutes left in this case. The judge is going to shut this shit down. Like, what the fuck?
I wasn't thinking about sending no money because I thought they were taking it out.
Okay. Well, the law doesn't allow me to there's nothing on file for me to address that, and I don't think there is a legal action to address that with, well, you could go look into it. But right now, there's nothing before me about that issue. But what is before me is there's arrears that were not paid, and they're requesting that I order a quadro to get them paid, or at least mostly get them paid, or somewhat get them paid, whatever amount is in that account. Are you objecting to me entering the quadro to get this resolved or mostly resolved?
I guess you could get it mostly resolved because I'm tired of it.
Okay, I'm based on that. I'm going to grant the quadro, and like Miss Villarreal just explained, what's in the account. If it's too much, they'll take less. If it's not enough, you'll still owe some child support. But this will at least get the arrears moving and hopefully mostly resolved. So I'm granting
No
the
problem.
quadro. And do you need them back in their breakout rooms to sign anything?
No, Judge, I was just going to file the proposed quadro order that was already drafted. I can refile it for your signature and approval, Judge.
Okay, thank you. So you are all free to go. It might take some time for all that paperwork to go through. They'll need a certified copy once I sign the order. Then it gets sent to the plan administrator. As I just spoke about before, glitches happen. Hopefully a glitch will not happen. I think the AG usually gets these pre-approved because they are very particular documents, but it does just take, I don't know why, it usually takes some time. So hopefully in a few months, ma'am, you'll have the money. And feel free to call them if a few months go by and it's still stalling, because sometimes it does need to get pushed, these quadros. Okay.
Thank you, Judge.
Thank you. You are all free to go for the day, and good luck with everything going forward. Thank you so much.
Thank you.
Wow.
I wish she had let him speak. I wish she had, but she didn't, ladies and gentlemen. She certainly didn't. Back in the kitchen. I love this fucking pantsuit. I feel great. I hope everybody had a wonderful night. We are working out all the glitches. Please make sure that you like the video. Subscribe to the channel if you haven't already. Subscribe your mom, your dad, whoever. You can turn the notifications off. Okay? I'm the only YouTuber telling you that. Turn the notifications off on the people's accounts that you subscribe without telling. No, you can't do that either. Terms and conditions. Anyways, I hope that everybody has a wonderful evening. We'll be back tomorrow. We got more coming at you. What is it tomorrow? Thursday. It's Thursday. Thank you again to everybody. And remember, oh yeah, Jean, thanks for being here. If you were new here and you didn't say hi, great. That's okay. Leave a comment. Hey, if you're in the future, leave me a comment. It'll blow my fucking mind. Seriously. When people comment on old videos, it blows my mind. You want to blow my mind? There you go. Easy hack. Anyways, I hope that you all have a wonderful evening. Remember that I love you, I'm proud of you, and I'll see you tomorrow. I said bye.
Ways down and